So we have a lot of fantastic content to cover today. So we're going to go ahead and get started. My name is Lisa Rice, and I'm the Chief Sales Officer here at Sanderson Firm. I'm going to be your moderator today, and we appreciate everybody taking the time to join us on this important topic on CMS finalizing the rule for Section 111 civil monetary penalties. I want to cover a few housekeeping items before we do our introductions and dive into the topic. We're happy to take questions during the webinar, so please feel free to put them in the Q&A chat function in Zoom, and we'll answer these either during the presentation or at the end if time permits. If we aren't able to get to your questions, we will respond to you directly to answer any questions that you may have. Feel free to reach out to me directly after the webinar. We'll be sending out a copy of the presentation along with the recording link to everyone. We'll go ahead and introduce our awesome speakers today. We have three of the top speakers in the industry to discuss today's topic. We have Heather Swartz Sanderson, who is our founder and CEO of Sanderson Firm. Heather's one of the foremost nationally recognized experts in Medicare secondary payer, and she's devoted over 15 years in the MSP space. Joining Heather is our managing attorney, Brendan D'Souza. Brendan manages our legal department and joined Sanderson Firm in 2021 after previously serving as in-house compliance counsel for one of the nation's largest Medicare secondary payer compliance companies. Last but not least, we have Kathy Bell, who is our Vice President of MSP Compliance. Kathy's been in the insurance claims industry for over 30 years and has worked for both carriers and TPAs. Before starting her career in Medicare secondary payer, Kathy actually oversees our Section 111 reporting department, helping sure our clients understand all aspects of Medicare reporting. So I'm going to turn everything over to them to get started.
Great. Hello, everyone. Thank you for joining today. And thank you so much, Lisa, for the introduction. Glad you are all here today. I'm sure it was not the most welcome item in your inbox last week when you received notification that the Centers for Medicare and Medicaid Services had, in fact, finally finalized the rule on civil money penalties for non-compliant Section 111 reporting. We're going to dive right in because there's a lot to know here. And I know that you all want to take away, some information back to your organizations that's going to be helpful in navigating this final rule, right? The big deal about the final rule being finalized, and we'll talk about it momentarily, is that we're now in a situation where Medicare can start issuing penalties in the very near future. So it's really important to understand what the final rule entails. First, we're going to do a brief background of the legislative history, and we're going to talk about why CMS actually had to rulemaking around civil money penalties and how the SMART Act facilitated that. We're going to talk about the final rule and what's within the final rule, when it becomes effective, when it's applicable. We're going to talk about CMS's definition of non-compliance and timeliness. We're also going to discuss any safe harbors that CMS has provided for responsible reporting entities, also known as RREs. We're going to try and make sure to define acronyms today so that everyone understands what we're talking about. But as far as safe harbors, so those areas in which an RRE or an insurance company or a self-insured entity that's reporting to CMS could prove that they had good faith efforts and are protected by safe harbors from any civil money penalty from CMS. We're going to talk about the appeals process proposed and how Medicare will give notice of a proposed CMP and how parties can then respond to that informal pre-notice from CMS. We're going to talk about how Medicare plans to audit insurance companies and RREs is in the way of how are they going to find out if you're not timely reporting your settlements and claims with Medicare beneficiaries. And then we're going to kind of discuss some closing thoughts, some points of interest, and also give you some very simple best practices to take away, which you want to think about going forward with your Section 111 reporting, right? So let's jump into the background. So first, the first legislative course of action, of course, was for Medicare to enact and enable the Medicare Secondary Payer Act. This was enacted in 1980, right? The intent behind the Medicare Secondary Payer Act was for Medicare to now hopefully pay secondary where there is a primary payer available in workers' compensation, general liability, and no-fault claims, right? Medicare wants to pay conditionally. Medicare doesn't want to pay for claims where there might be a primary payer. But, you know, with that law being passed, it was mostly dormant for a while, right? Because before Section 111 reporting came about, even though the Medicare Secondary Payer Act existed, there was no real enforcement behind the MSP, and Medicare did not have that visibility or transparency into claims and settlements with Medicare beneficiaries occurring. And so ultimately, again, another step in the process is 1981, which Congress enacts Section 128A to the Social Security Act, which allows CMS to issue civil monetary penalties for non-compliance, right? And then, as I was just alluding to, right, Medicare needed that transparency into claims and settlements happening so they could enforce Medicare secondary payer, and they could then recoup those conditional payments. So in 2007, Congress enacted the Section 111 Medicare and Medicaid S-CHIP Extension Act, right? And it's not listed here as a noteworthy time point, but I think we all should understand that even though the Medicare reporting law was enacted in 2007, CMS did not make it go live or become effective until 2010. It was January of 2010 where RREs started to report claims and settlements with Medicare beneficiaries to CMS. Now, one part that was problematic about the original Section 111 law requiring reporting was that the original language stated that Medicare would be able to impose a mandatory $1,000 per day per claim civil monetary penalty against a non-group health plan if they failed to report a claim or settlement with a Medicare beneficiary. So as an industry, and I was working in the industry still then too, I actually helped lobby for the SMART Act. We had it passed in 2013. And one of the main goals of the SMART Act of 2013 was we didn't want Medicare to be able to automatically be able to penalize an insurer for noncompliance when it was made out of mistake or systematic error. It was inherently unfair, right? We wanted there to be some wiggle room where Medicare could say, you know, on a tiered approach, how they would penalize an insurer depending upon the good faith efforts of the responsible reporting entity. And so, you know, out of the SMART Act, one of the key things we did when we got that passed in 2013 was that now the language would say Medicare can assess penalties up to $1,000 per day per claim. So now discretionary and up to $1,000 per day per claim rather than mandatory $1,000 per day per claim. One of the beautiful things about the SMART Act as well, you know, in addition to making penalties more discretionary, is that we kind of punted on Medicare being able to issue penalties for quite a while, because as a result of the SMART Act, Medicare now needed to legislatively rulemake and issue a final rule around those scenarios in which they would impose a civil money penalty against an NGHP RRE, right? So this was enacted in 2013, and now we didn't have the final rule on penalties till 2024. So that gave us some more time, right? Think about, we've been reporting since 2010. SMART Act changed the language to discretionary penalties. Medicare needed to rulemaking, and 11 years later, here we have it. And now with the final rule, Medicare can start issuing penalties after the effective date. So we did see prior to this final rule, there were other attempts at Medicare looking to legislatively rulemaking around civil monetary penalties. In 2013, they tried to initially do the rulemaking right after the SMART Act, and they later withdrew that rule. But in 2020, in February of 2020, we saw the proposed rule, and it was supposed to be finalized by February of 2023. And then Medicare let us know earlier on in this year that they were going to delay the final rule till potentially as late as February 2024. And then lo and behold, to our surprise, to some degree, actually, if you follow our blog, which I recommend that you do if you don't already, we're regularly blogging on CMS updates and trends. We're seeing the writing on the tea leaves that it looked like Medicare was going to issue a final rule sooner than February of 2024. So we issued a blog on that about a month ago, and we were telling our clients, now is the time to make sure you're ready for these penalties. And in fact, they did. So they published this final rule early. And so here we have it. And that's the topic of today. But I wanted to make sure everyone understands why and how we got here and why this is the pivotal moment. With that, I'm going to turn it on over to Brendan.
Thank you, Heather, and good afternoon, everyone, or potentially good morning from wherever you're calling in from. So, all right, so the final rule. So, I mean, like Heather said, CMS sort of dropped it on us almost without too much noise or anticipation on October 10th of last week. The final rule was very organized. As you can see here, this sort of breaks down just structurally how the final rule is organized with the background section and all that good stuff. But an interesting point there is, so it's a 37-page document, longer than the actual proposed rule itself. And that's actually because CMS did something interesting where they sort of incorporated notes from the proposed rule and comments into the final rule itself. So the final rule, of course, sort of starts with an intro background. Here's the legislative history. Here are the public comments that were received. And then Medicare gets into, okay, what are the bases for imposing a civil money penalty against an RRE? And so Medicare, in the final rule, actually sort of outlined, like, let's say an issue. So for example, a statute of limitations. Medicare would identify the issue. They would say, what the final rule says. They would also insert a comment or response to someone or an entity who made a specific comment on that particular issue in the original proposed rule. So you see that Medicare would talk about issues, say, this is why the final rule is different than the proposed rule, and sort of get into sort of a back and forth, almost like discussion with itself or with commentators from the previous rulemaking. So on first pass, it was a little confusing on how it was organized, but once you read it through again, it makes total sense. And it's actually pretty interesting how Medicare structured it itself. But again, as you can see, here's the rough layout of the final rule itself, and we'll kind of dig into each one of these components as we move through the presentation. Okay, so we had the, I guess, the first notice of the final rule on October 10th. In the final rule, Medicare said that it would be published the next day on October 11th. So October 11th, it's published in the Federal Register online. The final rule itself, it says in the document, says that it will become effective 60 days after its publication date. So 60 days after October 11th of 2023, which is, you see here, December 11th of 2023. So that's when it becomes effective, but it does not become applicable until 1 year after its publication date, which happens to fall on October 11th of 2024. So we have the effective date, the applicable date. What does all of this mean? So the CMP, civil money penalty, may not be imposed until at least 1 year after the later of either one, the applicability date, which is October 11th, 2024, or 1 year after the settlement date, or TPOC, or the assumption of ORM for responsibilities date that the NGHP or RRE was required to report. So we're going to see a lot of this. It's a little confusing, but you're going to see a lot of this 365 days or 1 year sort of leaping come in a lot in the final rule itself. So make sure, when you're looking at dates, ask yourself, okay, is this date a firm date, or do I have to consider or add 1 year plus to the date I'm looking at to comply with Medicare's requirements? And of course, the last bullet point here is, based on all of this, the effective date, the applicability date, RREs will have at least 1 year from October 11th, 2024, before any civil monetary penalty is contemplated.
So now let's look at what is the definition of noncompliance. The final rule basically defined noncompliance is that anytime CMS identifies that new beneficiary record that was not reported timely. But what does timeliness mean? So Medicare is looking at timeliness as 1 year from the date of the effective date of coverage, which would be your ORM. And keep in mind, ORM is your date of loss. The ORM flag is a yes or no, so it's just an on or off flag. And so it's always the date of loss. So that's 1 year from your date of loss or the date of settlement. And if there's a delayed funding, then it would be, based on that. And it's, again, that 1 year. So really important to consider that, again, the effective date for your ORM is the date of loss. So you need to report it 1 year from that date of loss. And you're only reporting quarterly. So as you're reporting this information, you need to keep that in mind, that you only report quarterly. And so if you're waiting till that last quarter, you may actually miss that date. So it's really important that you are, putting that information in timely so that it does get reported accurately. One question that might come up is what happens if you haven't reported it ORM because of the work comp ORM exclusion rule? Well, CMS has some safe harbors, and we're going to address those in the upcoming slides and talk about that. So,
I was going to ask you a question, Kathy, that just came to mind. You mentioned that failure to report the inception of ORM timely could be a problem because the quarterly reporting occurs, right? So, I mean, it would certainly be wise for, when they've got ORM on a claim and the next quarterly reporting period comes up, to report the ORM in the first quarterly report that comes up, right? They do certainly have wiggle room of a year, but it could get forgotten about in that time. What best practices have you seen with our Section 111 reporting clients, and so that they can make sure that adjusters are automatically flagging ORM in the next quarterly report in which they can? Is this a systematic issue? Is something with the claim system so that they can automatically trigger ORM? What recommendations do you have to our clients as far as, making sure that adjusters are flagging ORM timely when they've accepted a work comp or a no-fault claim?
Great question. Yeah, I think there are some of the claim systems out there, they will have flags because of the work comp ORM exclusion rule for those work comp claims. If you pay less than the $750, all of those rules, then you wouldn't have to report that claim. But you want to make sure that there's logic in place that once that breaches it, that it does get reported. Another thought is management reports. Something that we do with our reporting solution is that we make sure that our reporting clients know how many records that they have that are a Medicare beneficiary, but it's flagged as ORM as no. And we make sure that they know that on a monthly basis so that it's something that they can, monitor to make sure that those things are getting reported timely. So it's just a matter of, kind of checks and balances. And making sure that you do have the right logic in place or the right reports in place in order to address that, and then working with your reporting vendor to make sure that they are kind of monitoring that for you, and so that things don't get missed.
Very good.
So let's go ahead and go to the next slide. So there are now two eligible events for fines and penalties. The first is your untimely reporting of a TPOC. So again, you have 1 year from the date of that settlement to report that TPOC. Again, take in mind that you're only reporting quarterly. So you want to make sure that you're getting that put in as timely as possible so that it does get reported. The second one is the untimely reporting of the acceptance of ORM. This is going to, again, probably your work comp and your no-fault claims. And I will say, in looking at a lot of the data, the no-fault claims, which are your MedPay and your PIP claims, those are probably areas that, are a little confusing as to when they need to be reported or not. So something that, you want to look at and make sure that they are getting reported timely, because, again, it's 1 year and it's going to be the date of loss, because that's when the ongoing responsibility, that's when the flag turns on, and that's what they consider, that's when the eligibility starts. The next one, failure to register as an RRE. If you're not registered, you're not reporting at all, that's going to be an issue. And then failure to collect on the big five. And we're going to talk more about this in the next slide, but again, documenting that you've made every attempt possible to determine if that person is a Medicare beneficiary. So if you're going to say that I didn't report ORM or I didn't report the TPOC because I didn't know they were a Medicare beneficiary, you want to make sure that you've documented that you tried to find out. And so we're going to talk about that coming up. some of the things that CMS had previously proposed, but were eliminated was one, the error tolerance. So if you had 4 out of the 8 consecutive reporting periods that your data was not accepted because of the amount of errors, they've taken that out. And then they've also taken out if you had contradicting information in your reporting. So let's say that you had, 5 or 6 ICD codes and 3 of them were not related. Medicare had in the proposed rule indicated that they could fine and penalize you for that. They've taken that out. Also for the late reporting of ORM termination. But keep in mind that even though CMS has taken that out as far as penalties, you still want to make sure you're reporting stuff correctly. And again, we're going to touch base on this a little bit more, but don't take that as CMS doesn't care. They do. It's just they've said that they want to have the RREs report properly, and that's what they're asking. And they're going to fine you if you're just not reporting properly. But you want to make sure that you are continuing to report properly. So Medicare has kind of listed some of the safe harbors. So the non-group health plans, your NGHPs, they're protected against civil monetary penalties if there was a system or technical issue that was out of your control, and so you couldn't get it reported. If there was untimely reporting due to CMS or a contractor error, untimely reporting due to the lack of cooperation from the beneficiary to provide you with the necessary information. So as part of the proposed rule, Medicare had said that you needed to make a good faith effort in determining if somebody was a Medicare beneficiary, and that entailed 2 written forms of communication, 1 verbal or email form, making sure you documented your file, with all those attempts. They've pretty much kept that, except for they've added a little bit of more clarification. They've said that you need to have at least 2 attempts by mail or electronic mail, so either by mail or email. And then the 3rd attempt could be made by either telephone, mail, electronic mail, or some other reasonable method. An example of another reasonable method would be a Social Security research. We have a very robust service that we can do that. We can, check to see if we can find the Social Security number. We have about a 95% success rate. Minors are a little bit more difficult to find on that, but that's another method that you could actually document your file, that you've made every attempt possible to determine if that person is a Medicare beneficiary. You do want to make sure that you're, getting that information and then keeping it at least for 5 years, because Medicare has indicated that they could, audit based on that information. Another thing is that, we can even help at Sanderson Firm, we can help you with sending out those mailings, sending it to the claimant attorney, sending them, information as to why it's required, a copy of the CMS memo, all of that. And, something that we could follow up to take that burden off of the adjuster, that you have that documentation in your file. So to continue on, so CMS has also indicated that if they're going to make system alterations or changes, that they're going to give at least 6 months notice, and then they won't do any civil monetary penalties for 2 reporting cycles. They've also said that if they aren't able to give you 6 months notice of changes, that at least 1 year after that effective date of the implementation, that they won't fine for civil monetary penalties. This last one, I think this is where CMS is kind of addressing, if you had a claim that you didn't report because it fit within the work comp ORM exclusion rule, and then after that 1 year, it did, they breached that, and so now you have to report it. They basically said any other scenarios that may be inappropriate to penalize the non-group health plan. It's kind of a catch-all, and just something that Medicare or CMS has put in there so that it catches those reporting exclusions based on the Section 111 guidance that CMS has given us.
Okay, so we've talked about effective dates. We've talked about the bases for which a CMP can be imposed. We've talked about safe harbors. So how long exactly does Medicare have to impose a civil money penalty against an RE, against a non-compliant RE? So the proposed rule itself, as you remember, in 2020 was interesting. It proposed that the CMP could be imposed within 5 years from the date that the non-compliance was identified by CMS. That was a pretty nebulous wording there, because you say, okay, what if an RE was non-compliant in the year 2030, and let's say Medicare, for whatever reason, decided they're not going to impose a CMP until 2040, 10 years later. CMS could, and I'm not saying that CMS would ever do this, but under the 2020 version, CMS could say, hey, yeah, we know the non-compliance happened in 2030, but we didn't actually find it until 2038. So yeah, we're not really 10 years late. We're technically just a couple of years late. So thankfully, in the final rule, that language was eliminated. So there's no evidentiary concerns about when CMS, actually identified the error. Final rule says CMS will apply a 5-year statute of limitations date, 5 years from the date the non-compliance actually occurred. So once you actually report to Medicare, either the TPOC or the ORM or acceptance of ORM, that's what triggers the actual statute of limitations period. So just as a quick example here, because I know some people like myself are probably more visual learners. So Medicare actually provided an example in the final rule. And so just reading through the example here, let me move this pane over my screen so I can see the full thing. So if the date of settlement is January 1st of 2025, then the RRE will have 1 year from that date to report the coverage before potentially subject to the CMP. So it's like you have a TPOC on 2025, January 1. You will have until January 1 of 2026 to essentially be compliant. So if you do settle on January 1st of 2025, but you don't report that to CMS until October 15th of 2026, then the RRE will be considered non-compliant from the period of January 2nd, 2026 through October 15th of 2026. So you'll see that I mentioned earlier this whole 1 year jumping date. So always ask yourself when these sort of deadlines begin. And so the non-compliance isn't deemed effective until you actually report the claim to Medicare. So it doesn't matter when the event actually occurred. What matters is when you reported that event to CMS, and that's what will trigger the sort of 1 year jumping deadline. So in this case, if Medicare does not act until after October 15th of 2031, which is 5 years after the date that it was reported to Medicare, the statute of limitations has elapsed and no CMP will be imposed. We can up to the next slide here. So, okay, so this here sort of restates the final rule and the proposed rule, but the interesting thing to talk about here on the statute of limitations is a lot of people may ask, okay, it's 5 years, but why is the statute of limitations period not 3 years, at least as considered by the SMART Act, and maybe not even by the SMART Act, because we've seen recently lots of litigation with respect to both the government's cause of action and the private cause of action when it comes to Medicare and private Medicare plans asserting recovery rights against RREs who are late in refunding conditional payment amounts to either Medicare or the private Medicare plan itself. And we see in these statutes, these MSP recovery debt statutes, that Medicare and Medicare Advantage plans have a 3-year, very explicit, stated in the statute, 3-year statute of limitations period. We don't see this here. And Medicare specifically addressed this in the final rule itself. Medicare says that these 3-year limitations period are literally only for MSP debts, or in other words, they're only for conditional payment recoveries. So Medicare sees CMPs, these civil money penalties, as wholly distinct and separate and apart from Medicare's recovery of conditional payment amounts. So that's why Medicare references the 5-year statute that's found in Title 28 of the United States Code. So will this be challenged? It could be challenged potentially. That is, could a party argue that, hey, the 5 years statute of limitations should not apply? Maybe the 3-year statute of limitations will apply. We could see that in the future. As we'll talk about on the next slides, you will see that the appeals process for these CMPs is honestly kind of similar to the appeals process for conditional payments. So there's an administrative law judge phase. After that, there's a Department of Appeals Board phase. Then after that, as a level 5 phase, or I guess technically level 3 when it comes to CMPs, is the Circuit Court of Appeals or federal court. So it's entirely possible that some party will make the argument that, hey, Medicare was too late in seeking recovery of CMPs because actually a 3-year statute of limitations should have been imposed. So for now, as you need to know, the statute of limitations is 5 years, but we could of course see this argued in federal court that the 3-year statute of limitations could apply. Okay, so the appeals process. So one of the beautiful things about this rule is Medicare is just not going to levy a civil money penalty sort of ad hoc or without any real way for the RRE to provide any sort of defense. And one of the ways they do this is there's an informal written pre-notice process. So in the final rule, Medicare says, quote, "We intend to communicate with the entity informally before issuing notice regarding a CMP. The informal written pre-notice process will allow the RRE the opportunity to present mitigating evidence for CMS to review prior to the imposition of a CMP." So essentially, Medicare is going to, before even issuing a formal CMP against the entity, Medicare is going to issue a pre-written notice with which the RRE has 30 days to respond with mitigating information. And the final rule is clear that any reasonable mitigating information is permitted. There's no preset categories, which is great. So if you are an RE and you're presented with the sort of pre-notice CMP or any CMP really, the floodgates are open with respect to defenses that you can prepare. So probably 1 in the scope of defenses and probably 2 in the amount of defenses itself. There could be a bevy of reasons why reporting was not done timely, and you can present that to Medicare. And we can hop to the next slide here. And so after this 30-day informal notice, what follows from that is the written formal notice. So once CMS determines that a CMP will be imposed, that is, you have your 30 days, you did the informal notice, let's say Medicare, for whatever reason, just disagrees with your evidence and says, no, we're not buying it, we're still moving forward with the CMP. Medicare can then move forward with the formal written notice that a CMP will be imposed in accordance with the federal regulation. So the written notice is going to contain 3 things. It's going to contain 1, the information on the event that triggered the proposed CMP, that is why the CMP is being proposed in the first place. 2, the amount of the CMP itself, of course. And then lastly, next steps for the RRE or the non-group health plan NGHP. Next steps on how to request a hearing or sort of how to proceed further. So I'm guessing there's probably going to be just 2 options there. 1 is either pay the amount, or 2 is just appeal it further, appeal it to an ALJ or appeal it to the DAB. A great thing here, which is a change from the proposed rule, is there's no requirement that an attorney become involved in this process. So in 2020, if you remember in the proposed rule, it said that if you are an organization and there's a CMP imposed against you, if you want to dispute that at all, you've got to have an attorney handling the file. And that's because all of these appeals are going to be on record. And like I said previously, these are going to be somewhat similar to how conditional payments are handled. There's going to be an administrative law judge. And for those of you who are familiar with that process, at the ALJ level and above, once those start, those are actually formal hearings on the record. So you're going to most likely call in to a number, introduce yourself, state your organization, state which party you're speaking on behalf of. The judge is literally going to say on the line, I'm reading through the entire record. By the way, your name is going in the record and everything is being recorded. That way, if there's further appeals potentially to federal court, federal judges are going to have access to the record. So it's nice that no attorney involvement is required, but just note that just because no attorney involvement is required doesn't mean that you should take this any less serious than you would any conditional payment issue or any, I guess, that doesn't diminish the seriousness of the CMP itself. So for that reason, we still definitely recommend that professionals are involved in the process. They don't have to be attorneys, but someone who definitely knows what's going on with the file.
So let's talk about penalties. As Heather kind of talked about, the SMART Act, it provided us the benefit that CMS could tier the penalties. The group health plans didn't get this benefit. So kudos to those that thought about it, back in 2013 to make sure that this got in. So what they've identified is that if you are non-compliant, so you fail to report, the daily penalty is going to be $250 if you report it 1 year or more, but less than 2 after the required report date. It then goes up to $500 per day for anything that's reported 2 or more years, but less than 3 years, and then up to that $1,000 per day for anything over the 3 years. They have, outlined that they're going to cap it at the $365,000 per year, for that penalty. But again, that's kind of a benefit that the SMART Act gave us, that they tiered it. So again, if you're, if it doesn't get reported, it's something you want to capture as soon as possible, because the longer it goes, the more it's going to cost you. So CMS has kind of outlined how they're going to monitor this. They kind of indicated that they have limited resources, but what they've outlined is that they're going to audit approximately 1,000 claims or beneficiaries, basically, per calendar year across all RREs, and that includes both the non-group health plans as well as the group health plans. It's going to be divided evenly over the quarter, so 250 individual records per quarter. But what they've indicated is that they're going to take a little bit closer look, and it's going to be more of a manual review process. There's not going to be any automation, so no mass computer things. So that kind of tells us that they're going to, take a little bit deeper dive into reviewing these to determine if, the proper reporting is being done. And then it's also going to give them that benefit to be able to monitor the trends that are happening. It's likely too that they could identify those RREs that aren't registered, and that's how they're going to capture them. So it's just going to be a bit more of a manual process in reviewing all of that information. They have indicated that that they are not going to impose CMPs if the information contradicts what's being reported or exceeding the tolerance areas. But don't take that as something that you still want to make sure that you're reporting properly. If you don't report, like the ORM terminations, if you're not reporting that information correctly, that can affect a beneficiary's benefits. And it's also going to affect the conditional payment recovery efforts that you're getting. Keep in mind that, Medicare can still, they're going to do those conditional payment recovery efforts. And if you don't address those, they get to the Treasury. And once they get to Treasury, it's very difficult to pull that money back. So you want to make sure that even though, CMS isn't going to impose the penalties, that you don't take that lightly. It's still important that you're reporting properly, that you are getting, claims reported over, that you aren't exceeding your error tolerances that holds up a file being accepted by CMS. It's still very important. They've also indicated that they're not going to impose CMPs again for that termination and the wrong ICD codes. But again, that's all going to affect, that conditional payment recovery effort, that beneficiary's coverage. We see on a daily basis where a Medicare beneficiary goes in for treatment and they're denied care because of the fact that they have an open work comp claim and the ORM has never been terminated, or the wrong ICD code was reported for a TPOC, which is your total payment obligation to claim it. Your settlement was reported improperly, and so now they can't get the benefits. And that's very confusing because, keep in mind, most Medicare beneficiaries are probably older, and so it's confusing to them. They don't understand, and that just causes, additional stress for them. So something we want to make sure that as an industry that we are avoiding. And then we are experiencing, in fact, we blogged about this just a couple weeks ago about the increased recovery letters that we've seen recently. So the BCRC, they're auditing RREs that fail to terminate ORM properly, leaving it open. They're also auditing RREs that reported the TPOCs late. So the contractors are still looking at that information, even though there might not be a penalty associated with it. They're still looking at that information. So, don't become lax on the fact that that the penalties only apply to reporting of a TPOC, reporting of ORM. The other information is still just as important. Making sure you're terminating ORM when it's proper to do so, making sure that you're reporting the correct ICD codes, so that everything doesn't tie up, beneficiaries' benefits and things like that. So kind of the impact. There's about 21,000 registered, RREs for the non-group health plans. And so CMS kind of outlined, what they thought. And they basically said that assuming that the rule had gone into effect in 2022, that for the non-group health plans, there would have been about, let me get that number, 42 million in penalties. So you can see that, that's still a significant amount of money. So it's just, with these, they're asking for the industry to make sure that you're reporting properly. And so, just making sure that, you are getting that information into your system to avoid those penalties. But they've done us a favor by, scaling it back, but it's still really important. So kind of some of the best practices, again, making sure that you are reporting your ORM, timely. Again, work with your vendor. We make sure that we're communicating with our clients on a monthly basis as to, how many claims, how many Medicare beneficiary claims do they have? How many have ORM? How many have ORM is no? Is that right? Is that something that we need to look at? Do we need to audit that? Because you want to make sure, again, that you are reporting those timely, and you have a year, but it's quarterly reporting. And if you miss that, then you could be opening yourselves up for, potentially fines. And then, reporting of that TPOC, it's just so important that, once you're settling that claim, getting that information into your claim system so that it's getting over, but making sure that you're addressing any errors. Just because you put the TPOC in your system, if you have errors, then that claim may not get over to Medicare because you're missing other information. You're missing a TPOC date. You're missing the ICD code. You're missing, some piece of information that is required for that claim to make sure that it gets over to CMS. So, addressing those, and that, that you're aware of what errors are on those claims, and, making sure that you're being communicated with that information. And then documenting that, the big five. So that's first name, last name, date of birth, social security number, gender. Document all the efforts that you've made to retain that information and then keep it for 5 years. Again, doing that social security research. That's another form of documentation that you've made every attempt possible to get that information.
For sure. So we just want to kind of run through a couple of scenarios that we discussed internally. So let's assume that an NGHP RRE insurance company actually settles a case with a Medicare beneficiary and fails to actually query their Medicare status, or fails to actually, report the settlement to Medicare. And then let's say the plaintiff or claimant attorney who knows the person's on Medicare now makes that self-report to the BCRC to notify Medicare of settlement. So now the BCRC or CRC has initiated the common working file for the Medicare beneficiary, right? But unfortunately, the responsible reporting entity failed to report this settlement, but Medicare has now been made aware that there is a settlement with a Medicare beneficiary, and the RRE didn't report. We believe, and we've discussed this internally, that potentially the beneficiary's attorney's reporting of the settlement to Medicare could actually, warn CMS that the RRE has failed to actually report the claim. It could open up a whole other can of worms, because I'm sure that CMS would suspect that if one claim has gone non-reported, there's probably others within that RRE. How do you think that would go, Kathy, in that scenario?
Yeah, it's going to be probably a red flag. The fact that the attorney reported it has nothing to do with the Section 111. The civil monetary penalties are still going to be there. And if they see a lot of that, then I think that's a red flag, and it may open that RRE for an additional audit.
Right, for sure. So now let's consider another scenario. Let's say that an RRE just automatically, because they work with work comp or no fault claims that typically have ongoing responsibility for medical, and they automatically accept it on all claims regardless of the actual disposition of the claim. Could the non-group health plan RRE be exposed to CMPs, right, for this practice? So they're telling Medicare, we have ORM, when it might not be the case, right? And then the Medicare beneficiary might be denied coverage because they believe there's an available work comp payer or no fault payer, but in fact, in reality, the work comp or no fault payer has actually denied the claim, even though they've flagged ORM as Y in their system. What do you think this would, cause to happen at CMS, Brendan, through this auditing process? Where they're actually just automatically flagging ORM as yes, but that might not be the case.
Yeah, and I seriously love this example. we can even take it a step further. I mean, what if we assume that this NGHP sort of willfully, intentionally, just with malice says, okay, CMS, we know the scenarios that will actually trigger a CMP. And so, and the CMPs are all based on timeliness right now. They're not based off of, the accuracy of the data itself. So let's say you find yourself with a scenario where the RRE sort of does this, like you said, they have a practice of just automatically flagging RM no matter what. And the RRE says, look, Medicare, we're doing this. What are you going to do about it? Under the final rule, Medicare can't do anything. This is not a basis to where a CMP can be imposed. And so it's a little unfortunate, because it definitely causes issue with the Medicare beneficiaries themselves, because it causes coordination of benefit issues. So it doesn't matter that this RE is intentionally reporting false data, intentionally, really fogging up resources. One, you have to consider, look, if the NGHP is just flagging everything as yes, no matter what the actual claim disposition is, that's going to result in conditional payment recovery efforts. Medicare has already swamped their contractors on conditional payment appeals and disputes. If you just inject this, I don't know, let's say out of the 21,000 RREs, just because of this final rule itself, let's say 500 of those RREs just say, yeah, we're just going to flag this as yes, no matter what. You're going to have 100,000 potentially more claims that are just flooded into Medicare that have to be disputed. So that's unfortunate. And of course, also too is unfortunate that you're dealing with individuals who are Medicare beneficiaries. And if Medicare is not getting the correct information, Medicare is going to be confused. So you could be a Medicare beneficiary, you go for treatment, Medicare could deny payment for your medical treatment on the basis that, hey, actually, this insurance carrier is saying that they're responsible, so we're not going to pay for your treatment, even though in reality, the insurance carrier isn't responsible at all. So it's definitely going to create some issues, both on the beneficiary end and also with respect to drawing up administrative resources.
Well, and keep in mind with the SMART Act, they have 3 years from the date that you report through the Section 111 data, the ORM termination. So if they're reporting everything as yes, and then they don't report an ORM termination, the contractors, so then finally, they decide to report it. But during that time, CMS has that right for, conditional payment recovery efforts. So you're going to constantly be, addressing these conditional payments just because you reported yes, but then you decided that, you didn't want to report the ORM termination, or you didn't want to look at that. And then once you do, again, you still have that 3 years. And, for actuarial purposes, most insurance companies want to get those claims closed and know they're off the books. And if they're not doing that, reporting properly, that could cause a lot of issues there.
For sure. Excellent point. So just last sort of scenario hypothetical, and then we certainly want to get to, we have a ton of questions today. So we're going to hope to get to those at the end. But just lastly, we do see, scenarios like this, right? We have work with non-group health plan RREs that, have been reporting claims in good faith and actually have a very stellar record, of timely reporting claims to Medicare and takes MSP compliance seriously. But let's say in that scenario, they've got one beneficiary record that's 4 years non-compliant with reporting the TPOC. And then they missed this one particular Medicare beneficiary record for 16 straight reporting quarters. It just caught it now 4 years later. So this model of tiered penalties that CMS has just released under the final rule, which tier would they be exposed to? What are your thoughts there, Kathy?
But I mean, I think they're going to be exposed to that, that $1,000 a day, penalty, and again, $365,000 a year, and you're going to, get that year over year until you get it reported properly. So, it can add up, and it can add up fast. So, it is, something that you just want to make sure that you're, doing your best, your due diligence, and again, you have those kind of safety nets in place, that you have, multiple things maybe that you're looking at to make sure that you're getting reported. And again, I just think it's so important to have that relationship with your reporting vendor, that they're helping you try to identify some of those.
For sure. And so I think it certainly highlights the importance of, professional audits, which we're going to talk about our Section 111 audit solution here in a moment, but just kind of uncovering those patterns that you might not know were occurring. We recently audited an RRE that had both work comp and liability claims. And we realized on their work comp claims, they'd never really ever reported TPOCs. They thought TPOCs were only applicable in their liability claims. And so, and it just, was a misunderstanding among someone there. And, that's obviously a serious issue. So that's the benefit of, making sure that you have, a potential audit. And I'm going to let Lisa take over here and talk about our overall MSP services and our Section 11 services, and then we'll take questions.
Yeah, thank you, Heather. Yeah, we are focused on all things Medicare. So Medicare set-asides, medical cost projections, indemnified MSAs. We also handle conditional payment verifications, evaluations of disputes and appeals. Also with Medicaid, lien negotiations and settlement guidance. We also handle Section 111 reporting, provide guidance, consultations, and audits, which we'll talk about more in a minute. We also offer the SSN and date of birth research service that Kathy brought up. We have coming up that we'll be offering our clients our CMP appeals. We also offer MSP legal advice, settlement release language, opinion letters. You can go to the next slide, Heather.
So our Section 111 Sanderson comply, again, it's a very robust system. We pre-validate information to make sure that everything is correct before it's going over to Medicare. And again, we're providing you with visibility. We don't just transfer data back and forth. We look at it on a monthly basis to make sure that everything looks to be in line, or if there's some anomalies, let's talk about it. Everybody has a little bit different way to do things, and there sometimes are multiple ways to do things, but we want to make sure that everybody's aware and that we are communicating that with our clients, and reviewing best practices. And Heather kind of briefly touched based on the Medicare Advantage plans. We're seeing more and more people enrolled in these Medicare Advantage plans, and it's so important that they're being addressed because, they're very litigious. That's their only avenue. It's not like the CMS contractors where, they just give it over to Treasury and Treasury takes the money. They have to file suit. So we're seeing that, and that's just costly for everyone. So something that we want to make sure that, you're aware of those Medicare Advantage plans. And then, looking, we can help with some error corrections or, give some insight on what should be done in getting that data cleaned up so that it is being reported properly. And then we have our Sanderson firm audit. So what we do is, we get information from your claim system, and then, we take that information and we dissect it to, determine, are you being compliant? Are you reporting those claims? Are there situations that, maybe we need to look at? As Heather indicated, we just did one recently, and we found that, they were a liability program and they were reporting ORM as yes on quite a few of them. Typically that's not something that we see. I mean, it can happen, but, something that we want to talk about. We want to find out, why is that happening, and is it right? Because again, that's opening up, it may not even be, related to monetary penalties, but it's related to conditional payments. So it all kind of flows together. I mean, what the civil monetary penalties are doing is asking that the RREs are reporting properly. So they're reporting those TPOCs and the ORM, but it goes further. It doesn't just stop there. So with the audit, we try to, look at, is there things that, we need to, dive into further to figure out, what are your practices? How is this information getting put in? Are there safety nets in place? Making those recommendations, and just analyzing all of that data, to determine, your compliance level.
Great. Well, I think it's time to take some Q&A. We have a lot of questions. Many of them, I don't think we're going to get to all of them today, Lisa. But maybe you can pick, 3 to 4 that we can get to in the next 4 minutes or so. And then after that, we will be sure to get back to folks on their particular question. I know we're keeping notes on all the questions that have come in. If they've identified their name, we're going to get back to you if we don't get to your question.
And if we don't get to your question and you asked it anonymously, if you want to send an email, we'll attempt to get through all those. The first one is, can they fine you for something prior to the ruling or just going forward?
So that's an excellent question. So when we were looking at the proposed rule, historically, it looked like Medicare could go retroactively because of the way that the statute of limitations was worded. But with the final rule here, it appears that Medicare will not be issuing any civil monetary penalties for any settlements that occur prior to the applicable date of the final rule, which is October 11th, 2024. So theoretically, no, Medicare cannot now issue penalties for historical claims. However, and as Kathy was talking about earlier, that does not mean you should not be lax or that you should not care about your historical data. What we're finding through our audits are trends that are going on a number of years that are incorrectly reporting data to Medicare. As we talked about, we audited one carrier that was reporting ORM on liability claims. We uncovered another carrier that was reporting no TPOCs on their work comp settlements. You want to look at your data now and make sure it's cleaned up, just to make sure that you're not going to be improperly reporting data in the future. And let's be clear, October of next year, even though it's a year away, will come very quickly. And if you're working with a lot of claims, this is something you want to get underway very soon.
Next question, if handling a third-party claim and the claimant is attorney represented, who's responsible for the Medicare, Medicaid liens? Example, if attorney states they will handle all liens, does that let the carrier off the hook?
Brennan, why don't you take that one?
Yeah, so Medicare has what's called as or at least what's known as a super lien. So under the federal regulations, you cannot, Medicare can seek recovery of conditional payments from any party. So it doesn't matter in your settlement language if you say, hey, we, the insurance carrier, are going to have the plaintiff or the claimant reimburse Medicare for conditional payment amounts. That technically doesn't matter, if there's a settlement with those specific terms and the plaintiff or claimant or their attorney do not reimburse Medicare, and let's even assume the settlement fund is even paid out over to them, so the claimant has their money, Medicare can still seek recovery against the carrier or the employer for recovery of those conditional payment amounts. So it's not something that you can sort of get away from.
And again, based on that SMART Act, they have 3 years. So if you settle it today, Medicare has 3 years from the date that they get it through the Section 111 data. So if that claimant or plaintiff attorney fails to take care of that and Medicare finds out about it, 2.5 years later, they can come knocking on that RRE's door saying, you know, we want the money back. And you know, so now you have a closed claim that you've, you know, that's been off your books, and now you're going to be responsible for this conditional payment.
And I do want to put a plug in, if you all are interested more in conditional payments, our next webinar and probably our last webinar of 2023 is taking place on November 2nd at 1 p.m. Eastern time. You can find the link to register for that webinar on the events tab of our website at sandersoncomp.com. So we'll be talking more in detail about conditional payments, but you know, I think at this point in time, we need to close the webinar in the interest of time. We will get back to everyone on those questions not answered. We appreciate everyone's time today. Thank you so much for joining us and for looking to Sanderson Firm as a resource with this really important update from CMS. And we hope you all have a wonderful day, and thanks for attending.